Today I want to talk to you about what happens in a case when one doesn't have a will and they pass away.
Correct. So I think this is one of the biggest mistakes one could do when you have assets in your name and you have not planned for it. So we should avoid this situation and make sure that there is a will. But in case if a person dies without a will, then what happens is, if you are a Hindu, Sikh, Jain or a Buddhist, then you are subject to the Hindu Succession Act of 1956 and its amendment in 2005 will be applicable depending on the religion which you follow. And these four religions, Hinduism, Sikhism, Jainism and Buddhism, will follow this Succession Act, and that Succession Act has a lot of points to be taken care of. So you will be subject to the Succession Act in this case if you follow one of these four religions.
That's how important making a will is, because if you spend all your life creating a legacy to leave behind for your children, and if you don't have a will, it sort of undoes the whole process of your living years that you've spent creating this empire for your children. Feroz, also let's talk about these other sort of laws, because at the end of the day we live in a country which is India, and if one doesn't have a will, because most people don't have a will when they pass away, can you take us through what we need to keep in mind if one is following the Hindu law?
See, when you die without having a will, then the Hindu succession law actually categorizes the beneficiaries into four separate categories: class 1 heirs, class 2, and agnates and cognates. These are the four categories in which the legatees could actually possibly be there. So Hindu succession law says if you have died without a will, class 1 heirs will first be given the money and the estate in the form of property and any other assets which you actually possess. And if class 1 heir doesn't exist, then you go to class 2. Class 1 and class 2 is an elaborate definition of closer proximity family, and closer proximity family again, but a little distant. Then if these two categories don't exist in your case as a testator because you have not made a will, then you go to agnates. Agnates are the male lineage of distant blood relatives. If you don't have agnates, then you go to cognates. Cognates are the male or the female legal blood relatives which the estate automatically goes to. These four categories in the chronological order of importance, depending on which category of beneficiaries you might be able to fit in your legatees into in the Succession Act of 1956. Hindu Succession Act is what I meant.
Right, and that of course revolves around a Hindu male passing away. What if a Hindu female passes away? How does her property get split or devolved?
See, if you are a Hindu female and you have assets in your name, and if you died without a will, the first right goes to son, daughter and husband, son, daughter or daughters and husband of the female who has died. The second is the legal heirs of the husband will get this estate. The third is mother and father. Then you have legal heirs of father, and the fifth category is legal heirs of the mother. So these are the five categories in which the Hindu Succession Act actually distributes the assets of a female who follows any of the four religions we just mentioned and dies without a will.
Is the distribution equal in nature, Feroz?
See, it is not equal in nature. It is in the form of priority, and it is not equal 5 divisions. It is if you if you don't have the first, is when you move on to the second. They don't have equal rights. They just first categories in the chronological order of importance.
Right. What about somebody who is a Muslim or a Christian? So start with the Muslim, and their will, I mean, they are of course post them passing away, the distribution is under the Islamic law or the Sharia law?
Yes. Correct. If they pass away without a will, the Sharia law is applicable. Then the Muslim Succession Act comes into picture, and then you have 3 categories or 2 categories. Heirs and sharers is one category, and then there is another which is called the residuaries, where the residual assets get distributed. So you have a simpler form of distribution, but it's important to know that in the Sharia law, it has a large portion of asset gone to the brother of the testator, for example, if you don't have a will, not to the immediate family, which is wife and children, but also your brother gets a significant portion of your assets if there is no will, then the Sharia law becomes applicable.